The motion to conduct motu proprio inquiry in aid of legislation on the request of the United States government for the extradition of Pastor Apollo C. Quiboloy is hereby granted. There is now before the committee a letter signed by the Honorable Congressman Percival Sendanya, requesting the Committee on Justice to conduct an inquiry in aid of legislation on the reported request of the United States government on the extradition of Pastor Apollo C. Quiboloy. May I request for a copy of the letter? Please let the chair read the letter. Chairperson, Committee on Justice, Dear Madam Chair, this is dated August 23, 2025. In light of the reported request of the United States government for the extradition of Mr. Apollo Quiboloy, I respectfully urge the Committee on Justice to conduct an inquiry in aid of legislation on this matter. There is an overwhelming public interest and concern over the process by which extradition requests are received, evaluated, and acted upon. It is imperative that Congress, through your committee, provide a forum where concerned agencies may clarify the status of the present request, explain the legal and procedural steps involved, and identify any gaps or ambiguities in our existing laws and treaties. This inquiry will not only help ensure transparency, fairness, and adherence to our international obligations, but also allow Congress to determine whether remedial or supplemental legislation is necessary to strengthen the country's extradition framework. Thank you for your attention to this request. Respectfully signed by the Honorable Percival Sendanya. May I direct the committee secretary to provide the members with a copy of this letter. With regards to this request of the Honorable Percy Sendanya that a motu proprio inquiry in aid of legislation be conducted on the extradition of Pastor Apollo C. Quiboloy, we are opening the floor for the comments of our committee members. The Honorable Joel Chua is recognized.
Thank you, Madam Chair. Madam Chair, I only have two issues with respect to the extradition of Mr. Apollo Quiboloy. My first question, Madam Chair, is that will extradition be considered by the requesting party while there are still pending cases against Mr. Quiboloy in the Philippines?
With the limited knowledge of the chair, upon reading of the treaty between the United States and the Philippines, it appears that even when there is pending cases in the requested party, the requesting party can initiate an extradition process in the Philippines. Congressman Chua.
Thank you. My second question is with respect to the timeline, Madam Chair. The timeline between the receipt by the Department of Foreign Affairs of the requested extradition of Mr. Apollo Quiboloy and the transmittal to the Department of Justice, and the timeline from the receipt by the DOJ to the filing of the petition for extradition.
For the guidance of all the members, there are two significant laws which must be considered in the discussion of this extradition. One is the treaty that was entered into by the United States government and the Philippine government back in 1994. The other one is PD 1069, which is the Philippine extradition law passed by former President Marcos Sr. back in 1977. If I will be basing my answer to the question of the Honorable Chua, in both laws, it is silent with respect to the timeline between the receipt of extradition by the DFA to its transmittal to DOJ, in the same way that it is silent with respect to timeline from the transmittal to DOJ to the filing of petition for extradition with the regional trial court. The Honorable Vice Chair Dumogan is recognized.
Thank you, Madam Chair. With all due respect to, of course, our colleague who made this letter, at this point in time, I do not know if it is proper for this committee to take jurisdiction over this issue when these are covered by our treaty between the government in the United States and, of course, existing laws of the Philippines. I do not have any doubt that the existing laws on extradition will be followed by the concerned agencies. So what will this committee do at this point in time when we have a lot of urgent matters that the committee should pay attention to? To me, as I said, at this point in time, there's no somewhat urgency for us to conduct an inquiry on this issue. Thank you, Madam Chair.
The Honorable Vice Chair Keith Flores is recognized.
Madam Chair, well, it is true the comments made by Congressman Dumogan. No? I also agree with some of it. No? But I also would like to know din na marami pa kasing questions when it comes to extradition. Na it's not really much of a siguro dinidiscuss na topic even in our jurisprudence. No? So, example lang po, I have a question like, kung may request for extradition ba, who will have jurisdiction? Is it the court that's hearing the case where the person who is requested to be extradited? Or is it another RTC court? No? These are things na siguro by taking it up in our committee, we could help define. No? We could help siguro refine. Kasi as the chairperson nga mentioned, it's based on a law that's made in 1977. No? So, revisiting it would not necessarily mean that we are infringing on any of the activities being undertaken by the courts. No? It's determining what can be done in the future, not in the present case of Pastor Quiboloy, Madam Chair.
Thank you. Any other member who wish to comment?
Yes, Madam Chair, may I be recognized?
The Honorable Chel Jokno is recognized.
First of all, may I put on record that I fully support the request of Representative Sendanya. Just for the information of the Chair and the members, there is an article in the Philippine-U.S. Extradition Treaty that provides for what is known as temporary surrender. This refers to a situation where the person subject of extradition has a pending case or cases in the Philippines, but is being extradited to face cases also in the United States. And as based on what I recall of the provision, the person subject of extradition may be brought to the United States to face the cases there and then returned to the Philippines after to continue with the cases that are pending here. Before the hearing today, I inquired as to the status of the cases pending in the Philippines, and I was informed that most, if not all, of the victims have already testified. Tuloy pa po ang trial. The defense has not yet proceeded with its evidence. But given that situation, I think it would not be a problem for us insofar as the victims here, since they have already testified. I would also agree with the observation made by the Honorable Chair that perhaps we could look back at the presidential decree because it does not provide for specific timelines. At the same time, we may want to know from the judiciary if there are specific rules that govern the periods for which to decide extradition cases. Thank you, Madam Chair.
Thank you, the Honorable Jokno.
Madam Chair,
Honorable Flores is recognized.
also in relation to what Congressman Jokno just mentioned, yung temporary surrender tsaka deferred surrender, even in the laws on the PD, it does not really state kung sino, who will make the determination po. And that's why I think that there is actually a need to look into the old PD. Now, it's not necessarily in the context of Pastor Quiboloy, because it's going to be moving forward now with what we can do in probable amendments to this particular presidential decree. Kasi nga po, let's say, who chooses whether it's temporary surrender or deferred surrender? Other than the timeline, no? So, sino ang mag-decide on that? The PD does not say so, no? So, as far as I've yung sa nabasa ko, no? So, again, siguro tama lang din po na bisitahin natin ulit, no? And revisit it and discuss it again in the form of an inquiry, no? In aid of legislation para makorek din natin itong gaps that are existing in the current PD po.
Any other member? Of course, we conform to the insights and positions which were shared by the Honorable Jokno, the Honorable Chua, the Honorable Kit Flores, and we consider as well the sentiment of the Honorable Dumogan. But with regards to the issue of urgency and propriety that was raised by the Honorable Vice Chair Dumogan, I wish to respond that it is within the jurisdiction and purview of the Committee on Justice to revisit our extradition law by way of an inquiry in aid of legislation, considering that we are dealing with the consequences of the treaty that was entered into by the Philippine government with the U.S. government, and the same pertains to the administration of justice and judiciary. At the very least, with the surrender or extradition of the extraditee, the administration of justice, which we are facilitating in our country, will somehow be affected. So it is the position of the chair that it is but proper that the committee takes jurisdiction over the request of the Honorable Percy Sardanya with respect to the conduct of motu proprio inquiry in aid of legislation with regards to the extradition of Pastor Apollo Quiboloy. The Honorable Vice Chair Dumogan is recognized.
Thank you, Madam Chair. Well, with respect to that point, but as far as the procedure of how the Apollo Quiboloy is to be extradited, as I said, at this point in time, it's already covered by our treaty and existing laws. But if it's, our point is to somewhat revisit and see how we can improve or the filing of a proper action to improve our extradition treaty or on this point, then I agree on that point. Not necessarily connected with the extradition of Quiboloy, because to me, I am sure the concerned agencies will be somewhat knowledgeable to implement our existing laws on this point. Thank you, Madam Chair.
To respond, Vice Chair Dumogan, our discussion of the reported request of the United States government for the extradition of Pastor Apollo Quiboloy will just be incidental to our mandate, which is legislation. Let us be reminded that the request of our colleague, the Honorable Sendanya, is a motu proprio inquiry in aid of legislation. So, for the record, I wish to state, while he mentions about the extradition of Pastor Apollo Quiboloy, the same will just be incidental because our ultimate objective is to respond to our mandate, which is to legislate. With that, I believe that the concern of the Vice Chair Dumogan has been addressed, and for some members who made their manifestations already, it seems that we are in the same direction about the power of the Congress to conduct motu proprio inquiry in aid of legislation, of course, upon the approval of the majority of the members present and with the conformity of the Committee on Rules. Any other member who would like to comment? Meantime, the Chair recognizes the presence of the Honorable Congressman King George Leandro Antonio V. Colliantes from the 3rd District of the Province of Batangas. Similarly, we recognize the presence of the Honorable Congressman Loreto S. Amante from the 3rd District of Laguna. Thank you for coming. To summarize, earlier manifestations and comments were made by the members of the committee, and for the information of those who just came, it was raised the following arguments or issues with respect to the existing laws on extradition in the Philippines were raised. One, whether an extradition process may be initiated by a foreign country when the extraditee has pending cases as well in the Philippines. Second, what is the timeline between the receipt of the request by the Department of Foreign Affairs to the transmittal to the Department of Justice? In the same manner, what is the timeline between the receipt by the DOJ to the filing of the petition for extradition with the proper regional trial court? Number 3, it was also raised, which court shall acquire jurisdiction over the request for extradition or petition for extradition, whether the court which has jurisdiction over the local cases or the court where the extraditee is a resident of, as mentioned in the treaty and even in PD 1069. The Honorable Chel Jokno likewise shared the two options enumerated in the treaty, which are the temporary surrender and the deferred surrender. By temporary surrender, upon granting of the petition for extradition, the extraditee shall be surrendered first to the requesting party, and upon conclusion of the proceedings in the requesting party, he will be returned to the Philippines to proceed with the prosecution, trial, or even service of sentence in the requested country. By deferred surrender, it means that the Philippines has to conclude first with the prosecution of the case or even the service of sentence in our country before we surrender the extraditee to the foreign country where they will be proceeding with their prosecution or trial. And last question that was raised is This was raised by the Honorable Flores. Between temporary surrender and deferred surrender, it was not mentioned really which or who will be exercising the authority to choose between the two options. Of course, we understand that in the treaty and even in PD 1069, it was made clear that it will be the Department of Justice through the Chief State Counsel who will be filing the petition for extradition. However, once the same is granted, faced with the two options, whether it is temporary surrender or deferred surrender, the question now is, who will exercise the authority to choose whether it will be temporary surrender or deferred surrender? Meantime, we would like to recognize as well the Honorable Congresswoman Eliza Mika M. Gonzalez, Deputy Majority Leader. Thank you for coming, ma'am.
Madam Chair, one last
The
issue.
Honorable Chua is recognized.
Thank you, Madam Chair. Madam Chair, I would just like to know, or if we may add another issue, what will happen to the what will happen if the extraditee is convicted by the courts of the requesting party? What will happen to the pending case in the Philippines? Convicted po.
That is another gray area in our laws. Ang question po ni Honorable Chua is, what if the extraditee is convicted by the foreign country? According to PD 1069, the extraditee will be returned to the state requested, the Philippines. But the question is, what will happen to the service of sentence imposed by the foreign country? This is another gray area which we cannot see the answer either in the treaty or in PD 1069. Basically, honorable colleagues, your honors, what we are facing right now, I believe, are the ambiguities or perhaps insufficiencies which we see from two existing laws. One is the treaty between the United States government and the Philippine government. We call it Extradition Treaty. And second is the Philippine Extradition Law passed in 1977. Some of the issues were raised already, and apparently the answers could not be found in both laws, which I believe is our mandate to address, for us to be able to improve our existing extradition law. Let us recognize that by treaty, we have obligation to the foreign country, to our contracting party, to abide by the obligations provided in the treaty. However, there are questions which answers could not be found in both laws, and these are the reasons why inquiry in aid of legislation are actually being conducted. So, for the guidance of our fellow members who just came, because I understand we are attending to so many committee hearings, mayroon pong sulat ang ating kagalang-galang Percival Sendanya. In summary, he is requesting that the Committee on Justice conduct a motu proprio inquiry in aid of legislation with respect to the extradition of Pastor Apollo Quiboloy. In relation to this letter, we made mention of the two significant laws. That is, one, the extradition treaty between the U.S. and the Philippines, which actually imposes obligation on the Philippines to extradite any person residing in the country who is facing criminal obligations or cases in a foreign country which is a party to the treaty. That is U.S. The other significant law is PD 1069, which was passed by former President Marcos Sr. back in 1977, which is our existing Philippine extradition law. I believe this was prompted by the first extradition treaty that was entered into by the Philippines, and that is with Indonesia. Mas nauna po yung ating extradition law kesa sa treaty with the United States. So, earlier, my dear colleagues, our members already raised various issues which answer could not be found in both laws, either the treaty or the Philippine extradition law, which are the reasons, I believe, why we have to respond to our mandate to address the ambiguities and insufficiencies, and let us remember that this inquiry in aid of legislation, while it touches the issues on Pastor Quiboloy, the same shall be incidental only, and what is primary is our response to our legislative mandate.
Madam Chair.
The Honorable Vice Chair Lagbas is recognized. Before you proceed, Honorable Vice Chair, let me recognize first the Honorable Congresswoman Janice Degamo from the 3rd District of Negros Oriental. Thank you, ma'am, for coming. Vice Chair Lagbas, you may proceed.
Madam Chair, just one last issue.
May I proceed, please?
We have recognized already Vice Chair Lagbas.
Yes, I will yield to Vice Chair Lagbas.
Thank you.
Thank you,
Vice
sir.
Chair Lagbas, please.
Yes. Earlier on, Madam Chair, there was a question as to what will happen if the subject accused is already sentenced or is still ongoing prosecution in the requested country. In Section 2 of the treaty, under temporary and deferred surrender, it provides here, and I quote, the requested state may postpone the extradition proceedings against a person who is being prosecuted or who is serving sentence in the state. The postponement may continue until the prosecution of the person sought has been concluded or until such person has served any sentence imposed. In addition to the manifestation of the Madam Chair, I agree that we should proceed with this inquiry for the reason that this will not be the first case, nor is this the first case, and I believe there will be other cases that the country will be facing. And at this point in time, this inquiry will provide us with ideas on the manner by which the implementing agencies or the subject agencies are trying to enforce the laws, the existing laws. We will know the problems, the Waterloos relative to these issues, and we will be able to find out what should be changed or what should be amended and what should be updated under our existing laws. I believe that it is just timely for us to pursue this kind of investigation so that we will have a clear guidance and all our laws will be updated in pursuing these matters, which I think will keep happening nowadays, Madam Chair.
Chair acknowledges the position of the Honorable Vice Chair Lagbas, and towards that end, in addressing the insufficiencies and the ambiguities, we will definitely be soliciting the help of concerned agencies like the DOJ and the Department of Foreign Affairs and perhaps the Office of the Solicitor General. Your first manifestation actually pertains to the deferred surrender, where if the extraditee is already facing prosecution or is serving sentence by deferred surrender, she has to conclude first serving the sentence before the extradition can be taken action. And what is lamenting about deferred surrender, if we will be waiting for such period of time, the evidence may no longer be available in the United States by the time that the extraditee concluded already the service of his sentence. So that is one consequence of the law which we really have to re-evaluate and revisit. Of course, ito pong our efforts to revisit the laws by way of motu proprio inquiry in aid of legislation will definitely be effective in future extradition cases and not with respect to those which are pending already. Any other members who would like to comment? The committee is actually authorized to conduct a motu proprio inquiry in aid of legislation upon approval of the majority of the members present and with conformity of the Committee on Rules. I stated earlier as well that this falls perfectly within the jurisdiction and purview of the Committee on Justice because the extradition treaty produces legal implications with respect to the judiciary and the administration of justice, which is among the mandates of the Committee on Justice. So, meantime, we recognize the presence of the Honorable Congresswoman Laarni Lavin Roque from the 4th District of Bukidnon. Thank you for coming, ma'am.
Madam Chair.
The Honorable Flores is recognized.
Madam Chair, in accordance with Section 2 of our rules governing inquiries in aid of legislation, I move that the Committee on Justice conduct an inquiry in aid of legislation in accordance not only with the request of Congressman Sendanya, but also to cover PD 1069 and all other related laws on extradition, Madam Chair. I so move.
There is a motion
Second, Madam Chair.
to conduct a motu proprio inquiry in aid of legislation on the reported request of the United States government for the extradition of Pastor Apollo Quiboloy. I
Second.
heard a second. The same has been seconded. Do I hear any objection? The chair hears none. The motion to conduct motu proprio inquiry in aid of legislation on the request of the United States government for the extradition of Pastor Apollo Quiboloy is hereby granted.